5 seconds to go. Start. Possession over a meager part of the property was delivered by the appellant to the respondents not simultaneously with the agreement but subsequently at some point of time. To that extent, the recital in the agreement and the averments made in the plaint filed by the respondents are false. On a major part of the property, the appellant has continued to remain in possession. As opposed to this, the respondents have neither pleaded nor brought material on record to hold that they have acted in such a way as to render inequitable the denial of specific performance and to hold that theirs would be a case of greater hardship over the hardship of the appellant. Upon an evaluation of the totality of the circumstances, we are of the opinion that the performance of the contract would involve such hardship on the appellant as he did not foresee, while the non-performance would not involve such hardship on the respondents. The contract, though valid at the time when it was entered, is engrossed into such circumstances that the performance thereof cannot be secured with precision. The present one is a case where the discretionary jurisdiction to decree the specific performance ought not to be exercised in favor of the respondents. In Nirmala Anand versus Advent Corporation Private Limited and others, reported in 2002 8 SCC 146, this court held as under. It is true that grant of decree of specific performance lies in the discretion of the court, and it is also well settled that it is not always necessary to grant specific performance simply for the reason that it is legal to do so. It is further well settled that the court, in its discretion, can impose any reasonable condition, including payment of an additional amount by one party to the other, while granting or refusing decree of specific performance. Whether the purchaser shall be directed to pay an additional amount to the seller or converse would depend upon the facts and circumstances of a case. Ordinarily, the plaintiff is not to be denied the relief of specific performance only on account of the phenomenal increase of price during the pendency of litigation. That may be in a given case one of the considerations besides many others to be taken into consideration for refusing the decree of specific performance. As a general rule, it cannot be held that ordinarily the plaintiff cannot be allowed to have for her alone the entire benefit of phenomenal increase of the value of the property during the pendency of the litigation. While balancing the equities, one of the considerations to be kept in view is as to who is the defaulting party. It is also to be borne in mind whether a party is trying to take undue advantage over the other, as also the hardship that may be caused to the defendant by directing specific performance. There may be other circumstances on which parties may not have any control. The totality of the circumstances is required to be seen. In K. Prakash versus B. R. Sampath Kumar, reported in 2015 1 SCC 597, this court held as under. Subsequent rise in price will not be treated as a hardship entailing refusal of the decree for specific performance. Rise in price is a normal change of circumstances, and therefore on that ground a decree for specific performance cannot be reversed. However, the court may take notice of the fact that there has been an increase in the price of the property and considering the other facts and circumstances of the case, this court, while granting decree for specific performance, can impose such condition which may to some extent compensate the defendant owner of the property. In Nanjappan versus Ramaswamy and another, reported in 2015-14 SCC 341, this court held as under Section 20 of the Specific Relief Act, grant of specific performance of contract is discretionary. Though the decree for specific performance is discretionary, yet the court is not bound to grant such a relief merely because it is lawful to do so. But the discretion of the court is not arbitrary but sound and reasonable, guided by judicial principles of law and capable of correction by a court of appeal, and should be properly exercised, keeping in view the settled principles of law as envisaged in Section 20 of the Act. The jurisdiction of decreeing specific performance is a discretion of the court, and it depends upon facts and circumstances of each case. The court would take into consideration circumstances of each case, conduct of the parties, recitals in the sale agreement, and the circumstances outside the contract have to be seen. In Sardar Singh versus Krishna Devi 1994 4 SCC 18, this court observed that as the court has to see the totality of the circumstances, conduct of the parties, and respective interests under the contract while granting refusing such relief. First sale agreement was executed on 30th September 1987, about 27 years ago. The property is situated in Coimbatore city, and over these years, value of property in Coimbatore city would have considerably increased. In Sardamani versus Raj Lakshmi and others 2011-12 SCC 18, this court has held that the value of the property escalate in the urban areas very fast, and it would not be equitable to grant specific performance after a lapse of long period of time. In the instant case, first agreement was executed on 30th September 1987, that is 27 years ago. In view of passage of time and escalation of value of the property, grant of specific relief of performance would give an unfair advantage to the respondents plaintiffs, whereas the performance of the contract would involve great hardship to the appellant defendant and his family members. In Ferodos Estates Private Limited versus P. Gopi Rathnam Dead and others, reported in 2020 INSC 586, this court held as under. Section 20, as it then stood, makes it clear that the jurisdiction to decree specific performance is discretionary, but that this discretion is not arbitrary but has to be exercised soundly and reasonably, guided by judicial principles and capable of correction by a court of appeal. See Section 21. Section 22 speaks of cases in which the court may properly exercise discretion not to decree specific performance. Significantly, under Clause A of subsection 2, what is to be seen is the terms of the contract or the conduct of the parties at the time of entering into the contract. Even other circumstances under which the contract was entered into refers only to circumstances that prevailed at the time of entering into the contract. It is only then that this exception kicks in, and this is when the plaintiff gets an unfair advantage over the defendant. Equally, under Clause B of subsection 2, the hardship involved is again at the time of entering into the contract, which is clear from the expression which he did not foresee. This is made clear beyond doubt by explanation 2 of section 20, which states that the only exception to the hardship principle contained in clause B of subsection 2 is where hardship results from an act of the plaintiff subsequent to the contract. Stop.